Welcome, everybody. Thank you so much for joining us for a summer camp of our WTO TRIPS Council, the WTO TRIPS Council response to COVID-19. I'm Catherine Matteux, an AIPPI member, chair of the TRIPS committee, and this is a webinar organized by the FTA AIPPI committee and the TRIPS committee. We are very lucky to have fantastic speakers in this session about a topic that is crucial for the IP community and for the community at large. It may look like a very high-level policy topic, but this is something that may change the way we live IP and we practice IP. So I'll do like the TRIPS committee does at its monthly sessions, present the speakers from east to west like the sun. This is an international organization and we are aware of how the world lives. So first of all, we are very lucky to have Anthony Tubman from Australia, but in fact, he is from the WTO, the director of WTO's Intellectual Property Government Procurement and Competition Division. And Tony Tubman is extremely aware of these issues of what the TRIPS Council is doing and the issues related to COVID. Tony Tubman had a career as a patent attorney, as a diplomat, also directed the Global Intellectual Property Issues Division of WIPO, and as I said, now he's serving at the WTO. Then next, we have a very learned scholar, Ken Shatlin, who's a professor of development studies at the extremely famous LSE, London School of Economics. And this is very important to get his feedback on the policy issues, the particular economic and where IP rights stand in the world, which is something that AIPPI has been extremely concerned by, as I'll mention later on. And then we have another very learned speaker, but then from the Americas. We are lucky to have Hans Sauer, who will give some views, and he is the Deputy General Counsel and Vice President for the Biotechnology Innovation Organization. And he's also extremely knowledgeable in this topic as an adjunct professor in Georgetown, former chief patent counsel at pharmaceutical companies. So here we have a panel of people who are hands-on with these policy, economic, and intellectual property law issues. Before I carry on with the big substance of the topic, I do have a couple of housekeeping issues to mention. We have, like in other AIPPI seminars, a Q&A session. There will be roughly 10 minutes to ask questions to these very learned speakers. Or to get some debate, as AIPPI knows how to generate debate. The Q&A, there is a Q&A function, as you may see, and that's where the questions should be submitted. And we'll see, we are totally prepared technically, so we'll be aware of this Q&A. No need to raise hands forever. And then for any technical problems you may face, there is the chat function to AIPPI events. And there will be a recording of today's session, and it will be on AIPPI's YouTube channel. So now let's move on. We spoke sufficiently about technicalities, and now let's go to the content of the session. This is not an issue that is new to AIPPI. Everybody has, we have faced a dramatic change during the COVID-19 pandemic, and there has been a lot of questioning on the purpose of IP rights and whether IP rights were serving their purpose or whether they should be limited. And that's what is going on within the WTO TRIPS Council response. But this debate, these political issues are not new to AIPPI. As you may see, and the PowerPoint slides will be available, we have previous AIPPI resolutions since the 60s about whether IP rights should be limited and in which ways patent rights may be limited. AIPPI in the past, in the 60s, and then at the beginning of this century, so had some resolutions on that respect. There has been also various position papers regarding what is going on before the WTO and regarding IP rights limitations and patent limitations related to the pandemic or responding to the pandemic, and whether what should happen with vaccines that are needed dramatically by the communities. So for that also, you have in the PowerPoint slides, you may see the position papers from AIPPI, where AIPPI has taken good note of the policy issues and of the legal issues and how the legal tools should be used. This being said, we are seeing big changes in international law, and we are seeing big changes that are happening before the WTO. There have been discussions, and one of the white papers from AIPPI was the response to those changes. And for that, we have the ministerial decision that has just celebrated its 1 year anniversary, the ministerial decision on the TRIPS agreement, and where a specific regime for certain products, and this being said, vaccine, has been set. I just mentioned this topic, but now I'll pass on the floor to someone who's much closer than myself to that issue and who has seen how these legal changes are taking place. So Tony Tubman from the WTO will be presenting you what has happened over the past year, and then we will get some comments for the other two speakers. So please, Tony, go ahead. So, Tony, I believe you need to unmute.
Yes, thank you. After 3 years of this, unbelievably, my mute button disappeared at the critical moment. So, my apologies. I'm certainly very glad to be unmuted because I'm delighted to be part of this webinar. I might say that it's one of the real privileges of this job to engage, in particular, with the practitioner community. Because as we'll touch on, I suppose, a lot of what we've been dealing with in Geneva can be quite abstract, can be quite political in character. And I might say that in the Secretariat, we're always delighted to engage with our friends and colleagues in the practitioner community. And AIPPI in particular has been an incredibly welcome and valued partner. To give a very brief update of what has been, quite a protracted process, I'm sure participants will be aware that early on in the pandemic there was an initial proposal by India and South Africa supported by a wide range of developing countries in the WTO, for what would be a fairly wide-ranging waiver of TRIPS obligations. So not a waiver of IP rights, as it's often portrayed, but a waiver of obligations country to country within the WTO framework. That did not attract consensus. What did attract consensus was the decision you've referred to, Catherine, just a year ago at our ministerial conference. And in mentioning that and the subsequent process, I'd like to draw out just very briefly three aspects: the legal aspects, the policy aspects, and the politics. And in all, to really suggest that it's worth looking at this decision with some perspective. So, from a legal point of view, for the most part, we see it simply as restating what is understood to be the legal situation. In short, the point that the patent rights in particular are not absolute in character, that there is scope for governments to override patent rights, particularly in something like a public health emergency. You might think that that's kind of obvious, that's embedded in patent law, but it proved that to be necessary to clarify that, to point that out in the context of the pandemic, because there was actual confusion about the nature of the black letter law. So from a legal point of view, for example, if we are asked as a secretariat, what are the mechanisms for giving effect to this decision, we would refer to existing law, existing domestic law. An example would be Section 1498 of the US Civil Code, the government authorised use provision there. Another example would be Crown use in UK law, Section 59 of the UK Patents Act. It's referring to that kind of mechanism. It is not in itself, it cannot in itself waive intellectual property. It's often portrayed as that. It doesn't do that, it can't do that, because it's at the international level. It is simply, for the most part, pointing out that this is scope. This is a scope for domestic policy action using mechanisms that are widely present in diverse forms in most patent laws. There is a specific streamlined version of the paperwork if it comes to compulsory licenses for export, and I can go into details there if there's time and patience, but that really boils down to the sequence in which you send emails to the WTO Secretariat. That decision focused on vaccines, the vaccine technologies. Unresolved was the question of whether the decision should also clarify the situation relating to therapeutics and diagnostics. Initially, 6 months was set for that question to be considered by our member governments. That would have led to a decision by December last year. That didn't take place, and another 6 months later, it still hasn't taken place. As I think we will hear in the course of this webinar, a number of governments have not taken a position on this matter. One of them is the United States, and the reason for that is a very compelling one. That is to say that there is a process underway, an inquiry underway in the US ITC, the International Trade Commission, which is not due to submit a report until October this year. At the same time, there has been a very significant debate in the TRIPS Council. The TRIPS Council is where our member governments meet to discuss these matters, to negotiate. Those negotiations have not yielded a solution, obviously, and currently we don't see an outcome emerging in the near future. That's not to say there hasn't been a very solid and substantive debate. In the webinar materials, I hope we can circulate some of the submissions made in this regard. One is from Mexico and Switzerland, a joint paper, which calls for a factual analysis of the situation relating to COVID therapeutics and diagnostics, and therefore posing the question of whether it is necessary to override patent rights in response to to concerns about access to therapeutics and diagnostics for COVID. More recently, there have been two papers, one a general paper from the African group of countries, calling for quite a wide-ranging discussion about the nature of technology transfer, because behind all of this is a long-standing debate about what it means to promote, facilitate, encourage, or even require technology transfer as part of the concerns of developing countries. So the African group has put this on the table as a broader debate. And quite recently, the United Kingdom has tabled a paper for the TRIPS Council to discuss looking at voluntary licensing mechanisms and calling for or setting out the framework of a debate for what are the factors that enable, encourage, make effective voluntary licensing of medical technologies. So, in a very short compass, that's the current situation. We are very aware that behind this is a broader policy question. What are the right policy choices, both in, if you like, normal times, but also in pandemic times? And I would simply say that it is helpful to distinguish between a process of legal clarification, which is largely factual, and because there's no specific advocacy or no specific preference, if you like, for any particular policy choice. This is seen as something for member governments themselves to work out and take their choices within the agreed framework. And finally, without being naive, of course, there are politics involved. Governments across the globe have been under enormous pressure, perhaps rightly so, to come up with appropriate responses to the pandemic. Not all governments got it right throughout, and there are some really fundamental political challenges. Intellectual property is part of the policy and political mix, but that's why I suggest it really is helpful to keep the specifics of the TRIPS Council work and the TRIPS Council decision into perspective. It isn't a debate about whether IP is good or bad. It is a specific mechanism that is essentially represented in most countries' domestic laws, one way or the other. Very, very rarely used, but there as a public policy safeguard. And the choice whether to make use of it or not is clearly not in the hands of the WTO. That would be a very strange situation. It is very much for individual governments to work out their policy choices within the agreed legal framework. That's as much as I can. That's the short version. As is evident, I could talk about this all afternoon, but I think I've had more than my fair share of the time. Thank you.
Thank you so much, Tony. And well, we hope that you will give us even more insights from the WTO, and it's very good for the practitioners to know what goes on in Geneva. So could we get some comments from the policy perspective? As you mentioned, keep the debate into perspective. So can we get some high-level ideas from academia? And Ken, would you like to comment on the status of the ministerial decision and what has mentioned Tony?
Sure, I'd be happy to. And thank you also for inviting me to participate on this panel. It's quite an honor. So I was glad that the way that Tony phrased it, which is that it's not a big issue here about the role of IP in innovation. It's a rather specific debate about a specific set of measures, whether they should be applying or not applying to a specific set of products at a specific time. And I do think the big issue here, sort of the overall big overarching issue, is how to get more technology transfer to happen when it's needed and where it's needed. And what I mean by when it's needed and where it's needed is whether it's in a pandemic or not in a pandemic. And I think Tony very rightly distinguished between normal times and pandemic times. And I think most importantly for the sake of this particular discussion about the extension of the June 22 WTO decision, is for vaccines versus therapeutics. And I think everybody probably knows this now after 3 years, we've been saying it, but where technology transfer is really essential is for the production and expansion of production of vaccines, particularly in a pandemic. I actually think technology transfer is less of an issue for most therapeutics, particularly small molecules like antivirals. And so there, I think it's a different set of issues. But the technology transfer is the key issue for the vaccines. I'll leave it there for now. Thank you.
Thanks so much. And now jumping to the ocean, Hans, can you comment, please, on well, the ministerial decision and what Tony and Ken have mentioned?
Yes, I'd be happy to. And so good morning to all of you who are more, on this side of the Atlantic. It's 7 o'clock in the morning here. I'm really pleased to get up early out of bed to be with you again. For me too, it's an honor to have been invited. Yes. So the ministerial decision of last year, and the now ongoing debate about whether the terms of that decision should be expanded to include COVID therapeutics and diagnostics. Yes, it is, I think, an important ongoing development that many, I think, even on this side of the Atlantic, view as, maybe one of the bigger and more important developments in international IP law and international frameworks that we've seen over the last decades. I think Tony made an appraisal of the decision with which, in general, I think one cannot disagree. But it is, and this became clear in the hearings of the International Trade Commission here in Washington, D.C., which was beginning to gather information about the wisdom and the parameters of what's happening on the ground with respect to the availability of COVID therapeutics or diagnostics, right? What are the conditions around the globe? What is the level of demand? What is the level of supply? I think it was often said, especially by civil society groups, that the ministerial decision actually doesn't change a lot in international law. It doesn't change a lot in the obligations of WTO members in what they're supposed to do. It relaxes, at least nominally, some of the constraints that are put around the production under compulsory licenses of products for exportation to third-party countries. And it relaxes some of the mechanisms that already exist under law. So all that is, I think, not being disputed, but it does raise certain odd questions. The TRIPS waiver decision, as it's become known, certainly was justified on the basis of great urgency driven by the COVID pandemic. Right? And yet the decision itself makes no reference to a crisis or the need for urgent implementation during times of emergency. It makes reference to COVID vaccines, but not to a crisis. It doesn't require a need-based assessment for the issuance of compulsory licenses and the like, right? So I think the rhetoric around the decision was driven by great urgency. The decision itself, however, makes no reference to its use during emergencies. It just applies for a fixed amount of years to COVID vaccines, which raises, I think, another observation, and that is that discussions, certainly as we observe them unfold in Geneva, often focus, I would say, on politics. I think they're affected by other issues that are in play at the WTO. right? The so-called TRIPS waiver was decided in the context of other issues that were on the table, like subsidies for fisheries, right? Internal subsidies for public food stock holdings, digital trade, things of that nature. So they become part of a calculus where IP rights are beginning to be traded for other things that are also important in international trade, all driven by pressure in the WTO to reach an agreement and a decision at the ministerial conference, right? For many countries, a decision had to happen. Pressure by WTO leadership on participating countries was really building up towards MC12 to the decision, right? So there was a lot of political pressure to come to something that looks like an international agreement. What was relatively less discussed, I think, and that is relevant to its potential expansion as well, was what are the facts on the ground that we're talking about, right? The ministerial decision, I have to say, was made at a time when the world was awash in vaccines. But even Piyush Goyal, the trade minister of India at the time, when he strenuously pushed for the decision in Geneva, also said, you know, for vaccines, this decision is largely irrelevant. We have enough vaccines. It's not going to make a difference. But the goal was always, even last summer, to expand the decision to COVID drugs and to COVID diagnostics. And that, I think, is something that I think we should well keep in mind as we go forward and debate whether the decision should be expanded. We should not only ask, do the facts on the ground, does the supply and demand situation justify an expansion of the waiver? We should also keep in mind that I think many who have observed this process have viewed it as being used as a vehicle and to loosen up, if you will, the existing international framework under TRIPS for the way IP rights are granted and enforced and the obligations that member companies have, or member countries have. So as we go forward, I think it's well to remind ourselves what conditions on the ground justify the expansion of a TRIPS waiver. I think we will get into this for therapeutics, for example. We know that those have been widely and early on licensed under the Medicines Patent Pool and through other mechanisms to manufacturers around the world. I don't think, for example, it would be fair to say that manufacture of COVID drugs, COVID therapeutics, if we can even define what we mean by that, is concentrated in a few hands and in a few countries. It is at this point in time widely dispersed around the globe. It is widely available to especially poorer countries. I will stop here. It's also very notable that there is a lot of focus in the context of this discussion on middle and upper income countries, upper and upper middle income countries that are usually not part of the Medicines Patent Pool licenses. What happens in those countries, I think, will be an important aspect of the dynamics of discussing the expansion of this waiver going forward.
Yeah, thank you so much. And yeah, you pointed out, like the other speakers, well, we have the ministerial decision, but within the ministerial decision, the big issue seems to be the extensions. And we had that deadline, a 6-month deadline that expired in December, and now we are like in a world of maybe negotiations related to these extensions. And you all pointed out that, well, one thing is the immediate legal effect of the ministerial decision, and from what I understand, it's not groundbreaking because the international law had some tools in that respect. But we had also this ministerial decision that came up to make some sort of political response within a global trade. So can we get some comments from the other speakers on the status of the extensions to therapeutics and diagnosis? Maybe Tony, could you give the audience a framework of what to expect? You already presented the ministerial decision, but maybe the audience can have a take-home message on what to expect in the next few months or years. So there's a route, and then we could have some comments from Ken on the policy issues related to that extension.
No, certainly, Catherine. I hope it's certain months and not years. That's for sure. Well, as you know, as we've covered, the decision from the ministerial. So the ministerial conference is the highest level of decision making in the World Trade Organization. It's 164 trade ministers getting together to do, you know, to cover the full sweep of trade issues. The mandate was given last June or June last year, you know, to consider the extension of the decision to therapeutics and diagnostics. That deadline has passed. That leaves open. It's in the hands of our member governments as to, you know, what that means in practice. But quite a number of governments have been saying, look, we need to pursue this. We need to resolve this question. The normal avenue would be at the level of the TRIPS Council, which is at the level of diplomats rather than ministers. As I've mentioned, that hasn't been successful so far. We do have an unusual procedural situation in that because, you know, the consensus rule applies to these kind of considerations, and you know, a very important player in the negotiations, of course, the US. There is this domestic process, the International Trade Commission study of the issue. The report is due out in mid-October. It would be released between then and mid-November. We don't know exactly when. That's clearly going to inform the debate. I think all of us working in the field have enormous respect for the ITC and the quality of its work. So, you know, everything else aside, I'm sure it's going to be a really valuable insight into the issues under consideration. However, we have the next ministerial conference coming up at the end of February, on the 24th of February, and you know, I think the hope within the system, if you like, would be that this issue can be resolved in advance of that ministerial, because there's other things to take up. The kind of issues that Hans has mentioned, indeed. There's a very full agenda for that ministerial conference. But I suppose, and this is me just personally speculating, that if it isn't possible to crunch through a decision at the working level, at the TRIPS Council level, then it's possible that it could find its way onto the ministerial conference agenda. That isn't the case at the current time, and it's procedurally eminently possible for members to come to an agreement, you know, even before the end of this year. But at the moment, you know, I simply have no basis to speculate on that. We'll just have to see. At the very least, we are seeing more information on the issue coming in. We are seeing a more structured discussion in the TRIPS Council about issues such as licensing, you know, voluntary licensing, and the kind of mechanisms that encourage that, as well as the empirical basis, the factual situation regarding access to therapeutics in particular. Information less clear on diagnostics, just harder to measure that. So we do have these various various work streams converging. But I quite genuinely cannot and must not actually, speculate on how the exact outcome would occur. We have a fantastic chair. The chair of the TRIPS Council is the Thai ambassador, and she's one of the most seasoned diplomats in the trade sphere in Geneva. Very engaged, very dynamic, and so given that this is absolutely a diplomatic process, it's nothing to do with what the Secretariat would like to see or do. It's very much the government's taking the lead and defining the outcome. So that's why I do myself somewhat humble. But procedurally, that's a situation. Hard to see a specific decision in the immediate term, in the short term. The US ITC report will be a really significant contribution to the substance of the debate. And we do have, in the broader context, we do have a ministerial conference scheduled for the 24th of February next year. So I can assure you that there'll be very, very intensive work between now and then. And I think from a systemic point of view, just completely neutrally, it would be in everyone's interest to try to reach an outcome before then.
Well, thank you so much, Tony. I've asked you to read on a crystal ball, and you gave us a couple of milestones. So at least a take-home message, something for the fall, and maybe something for February 2024. So thanks so much for providing us with a roadmap. And Ken, could you please comment and give us your policy and academia perspective on this time frame, and also on these issues? We see that the discussions are getting more structured in licensing, empirical studies. So could you please comment on these issues?
Sure, gladly. I mean, in terms of the time frame, as Tony said, the US ITC won't report for another few months. So nothing will happen until the US takes a position, and the US won't take a position, and the USTR won't take a position until the ITC reports to it. But let me say a little bit about where from academic research, where I would come down on this. To be clear, I never thought that the waiver made much sense with regard to vaccines, and that's for the reasons that I alluded to before. That for the rapid scale up of vaccines, you need to have technology transfer, and you also need to have a facilitating regulatory pathway for imitators to get in, and neither of those were there. So I never actually thought that I never really understood the vaccine, the waiver debate around vaccines. I never thought it would have made much of a difference. And therefore, I'm not surprised that nothing has happened on that front since June either. I think actually with therapeutics, and let's be clear, when we talk about therapeutics right now in June of 2023, we're talking mainly about Paxlovid, which is the antiviral being produced and distributed by Pfizer that's in high demand. I think there a waiver or the extension of this June 22 WTO decision would and could actually have an important effect. And I think it actually does matter. Here I am going to slightly disagree with what Hans said a few moments ago. I think here there really are important differences. According to Airfinity data, about 80% of therapeutic contracts between producers and countries have been with high-income countries. So we are seeing a pretty important discrepancies in the distribution of a key essential medicine that's needed now. We need that. These are the ones that are needed. I think actually this could have an effect. And so I think there's a need for it, and I think the extension of the June 22 decision could actually matter in this regard in the way that I never expected it to matter for vaccines. And the other thing I would just add to this is that I understand that there are concerns that even if we think that there's a need to do this, and even if we think that extending it could have this effect, there's a concern that doing this weakens the overall IP system, sort of as a chip in the armor of the CHIPS agreement and so on. And I think that those concerns can be addressed with careful drafting. I mean, the waiver can be extended and in a revised text however, needs to be in such a way that reduces some of the fears of what are the conditions and what are the time frames and so on. So I understand the concerns that people have that say, even though we think this could be effective, we're worried about the follow-on consequences of it. But I think that those concerns can be ameliorated with careful drafting, which is what I would expect to happen if the waiver is extended. Thanks.
Thank you so much. I believe that Hans may want to respond.
Yeah, well, yes, initially, I would say with a good level of agreement. I do agree that it's important to understand why COVID therapeutics, and there are many, but let's say it's maybe 3 that have been most talked about: remdesivir, Paxlovid, and molnupiravir. It's going to be important to understand why these products are being deployed, say, at different levels and different intensities in different parts of the world. And in order to understand that, maybe 2 observations. First, how the waiver came to be, at least from a US perspective, I believe informs this discussion about, how it's going to be extended, if at all. So from a US perspective, it requires us to go back to the spring of 2021. But at that time, vaccines were widely deployed in the United States, so they really started becoming available at that time. The US was on path to vaccinate not just like high-risk individuals, people living in nursing homes or healthcare professionals or older members of society. The US was on track to vaccinating, healthy college kids and everybody else around the country, right? At the same time, vaccines were being procured in the US under the strictures of the Defense Production Act, which aren't really export controls, but they work like export controls. The US was sitting on millions of doses of, for example, AstraZeneca vaccine that we knew we weren't even going to approve and use in the United States. And yet, I think the position of the US government at the time was, first, we'll take care of our own people, and then we'll help share it with the rest of the world. Now, that became an uncomfortable situation for the Biden administration, which wanted to present itself as re-engaging as a global public health leader and the right. So instead of sharing vaccines, the administration made a decision that it would be easier to assent to the sharing, if you will, of intellectual property. Mainly corporate intellectual property, right, which comes at relatively little cost to the administration. That was believed, I think, to send the right signal. But from a company's perspective, right, imagine you're a vaccine maker. This was a very difficult proposition, right? Vaccine makers, I can say this with confidence, don't make a distinction between a grandmother in Atlanta, Georgia, and a grandmother in Burkina Faso. They're the same to us, right? The distinction is made by others. The distinction is made by leaders whose obligations first run to their own populations and only secondarily to partners and others around the world. This is true for developed countries as well as developing countries. India, just like countries in Europe and countries in North America, ration the vaccines that it would export and reserve the lion's share for their own populations. By that, I agree, is a problem. I think it has poisoned the North-South climate for decades to come. I think part of the, strident debate over IP waivers going forward that we see in the WTO and in other fora like the World Health Organization go back, I think, to this toxic I think, event that happened in relations between the global north and the global south. At this point, I don't think it's any longer about COVID. It's about something much more basic in the global relationship between developing and developed countries. And that I think we need to acknowledge and we need to address. One quick observation, also from a US perspective, it was very interesting as far as the licensing and orderly dissemination of technology for especially therapeutics goes, to listen to the public hearings that the International Trade Commission held, where civil society groups and representatives of governments from the global south had a lot of airtime. And what struck me most in those conversations were discussions around how compulsory licensing is much, much better than voluntary licensing on many levels, right? I think the many licenses that were issued either bilaterally or under the medicines patent pool for COVID therapeutics were really dissed in those discussions. It was said, well, those don't work, they exclude half the world.
Thanks so much. And I think you raised a crucial question about the high level politics. And I think it's the perfect transition to, it's almost a transition and a conclusion to move on. We have what's going on in Geneva at the WTO, but as you mentioned, we are in a global political world, and we also have in Geneva the WHO, which all the speakers refer to, and right now, so that we can open up some thoughts on how the law is going to change. If the speakers could comment on this WHO treaty on the pandemic prevention, because it wishes also to answer to these policy questions. So could we start maybe with Tony, even if it's another organization? I'm sure that you're aware of what goes on in Geneva.
Absolutely. And as you can imagine, we've been following this process very carefully. We are not a participant. We are, once again, this is between the sovereign governments themselves who are negotiating what's called a pandemic instrument. But there's and for anyone following these issues, you should definitely get hold of the current negotiating draft, because it is a catalogue of critical issues, in particular concerning the IP system. There is, for example, well, to me, a still, well, frankly, rather mysterious reference to time-bound waivers of intellectual property rights in the event of a future pandemic. And, as somebody who's been working as a practitioner, as an official, as an international official, as an academic, I don't know what that means, to be honest. What is a time-bound waiver of intellectual property rights? There may be some overlap with existing mechanisms. This is from the point of view of governments having agencies to override patents, but it isn't clear. And there's a number of first of all, I should say that this is a negotiating draft. It is certainly there's still a long way to go before it's an agreed treaty, and so I wouldn't want to suggest that any of the very bracketed, very much debated and controversial language is instantly going to become international law. That's certainly not the case. I would see it more at this stage more as a catalogue of the kind of issues and interests that are at the fore, and from an intellectual property point of view, there really is this kind of a long-running fault line. I think Hans touched on it very well. To what extent are we talking about encouraging, promoting voluntary licensing as the default means of technology transfer, and what are the virtues? What's the advantage of overriding patents, involuntary licensing? The various categories that falls into, and that fault line continues. That debate continues. One of the, I might say, stepping back from the legal texts, one of the long-running policy debates in Geneva throughout this process has been, and by the way, in the height of the pandemic, we had these very frank discussions with the leading vaccine producers, and one of the questions was, so just what are the factors that encourage or discourage voluntary licensing? When from a rational corporate point of view, when does it make sense to do so? When does it not make sense to do? What are the factors involved? And as this audience will be well aware, there are legion, a wide range of factors at play. And I think one of the difficulties in addressing this in the very formal, very structured setting of an international negotiation is how do you take account of each of these factors? Even the text we have on the screen here, encouraging holders of patents, to waive royalties or to have an open licensing arrangement. Well, that's an encouragement. In practice, we are seeing, for example, companies in some situations agreeing to these kind of arrangements. The medicines patent pool is an example. And to me, ideally, we would see much more of a flow of a really candid, frank, pragmatic information coming from practical experience, feeding into the broader policy debate, rather than seeking intricate top-down solutions that won't necessarily, may be very difficult to implement anyway in practice. And there's a tendency to assume that these kind of issues can be and need only be addressed through the mechanism of international law, whereas in fact this is totally about choices by IP owners, by potential licensors and licensees, and by governments establishing various forms of encouragement, or indeed, various forms of intervention to push along the technology transfer process, or to open up technologies in different ways. There's even the role of the courts, which we haven't touched on, but to me, a lot of the lessons, the practical lessons, come from actual litigation. The Moderna Arbitrator's case in the US, where we saw a really interesting intervention by the US Department of Justice.
Yes.
Authorized use, this kind of thing. There's so much of this practical experience that can be fed into the debate. And this is why, I really do really encourage the practitioner community to engage, and not just at the, if you like, at the political level, but really thinking through the practicalities and the benefits of practical experience.
Thank you very much, and for giving more take-home messages to the IPPI members. I see it as an encouragement to building in the system. We are almost running out of time for the Q&A. Ken and Hans, would you like to comment very briefly on the WHO treaty, or shall I?
I'm more than happy for you to see if anybody in the audience has any questions at this point in the little time we have.
Well, thank you all three for your contribution. So I'm not seeing any questions from the audience. Let me. I'm not seeing any questions for the moment. I've got a question as a practitioner. I mean, I got, and I'm very enthusiastic by invitations and the invitation that Tony from the WTO gave us of input from practitioners. But how could, and here the audience is of AIPPI members, how could AIPPI members share their practical knowledge, because everybody does that. AIPPI, as you know, is patent and trademark attorneys, lawyers, and right owners. So it's a bunch of professionals specialized in intellectual property. And how could we give our input at the Geneva level?
Well, I guess in a way we're all in the same boat in that this ultimately is a conversation, is a negotiation between governments. But there is in Geneva there is a second tier. There is a great deal of policy discussion and policy debate. There's we have in the WTO coming up a public forum where these issues will be discussed, but it's partly just a matter of taking the initiative and convening seminars, workshops. There's certainly a great deal of interest. Say quite frankly, I've engaged with some of the public health officials who are involved in the WHO process, and at an individual level, they said, look, these issues are in front of us, but we really need background. We need a bit more information. It's not as though they cut off from that. It's a matter of setting up those informal avenues for engaging, because whatever you think about the particular directions taken, everyone I've been working with is really committed to everyone's committed to the same outcomes of more equitable, more effective distribution of medicines in a critical time. Just a disagreement about the best mechanisms of getting there, and with that comes a genuine interest in learning the practical lessons, particularly the practical lessons from the pandemic. There are limitations structurally, because the negotiations, we're not in the room ourselves. It's the governments themselves who are negotiating. But there are ample opportunities to engage at the practical level. And we, by the way, would be very, well, as you know, we've invited AIPPI to a number of our events, but we'd be very happy to work with AIPPI colleagues to put on seminars, workshops, mapping out the practicalities that we've been talking about. Whether that changes the overall dynamics, that's another question. But I do think there's every reason to engage and inform. And as I keep saying, and I really mean it, the practitioner point of view is to my mind, one of the most critical in this debate. And one of the ironies is I think practitioners are too busy doing the day job, doing important work to get involved in this kind of thing. But if you can spare the bandwidth, I think it would really be helpful for the overall, if you like, policy ecosystem here in Geneva.
Thank you very much, and we heard very well what you said. So we will come back probably with proposals and our practitioners' enthusiasm, while keeping with our ethical issues and secrecy, because that's the tricky part. It's that, and I guess that Hans would echo what I say, that the problem of a lot of technology transfer and collaborations are sometimes under confidential provisions, but we do know that it does exist, technological transfer, and we know how IP rights can be used for the best. So we'll see how we can keep on work. And as you said, it's true that, well, we're having this webinar, and for Europeans, it's at lunchtime, which is very convenient because the rest of the day we go to court, we draft patents. So that's what we do. But I think it would be very sad to finish this webinar only thinking of studying and only thinking about work, policy. I think that we can practice in a very interesting way. And one of the proposals I'm going to make to the audience, well, first, there is, as I said, the Free Trade Agreements Committee and the TRIPS Committee that work in these issues and that try to get input from the WTO at various levels, from the academia, as we got today, and also from the industry, as we say in French, l'industrie. All this, it's very important not to be only in legal books and only at registries. There's the committee work, but there's also the core of AIPPI who pushed who was very related to the Paris Convention, and AIPPI and its fabulous Congress. So we could keep on this thinking and these discussions, not in a year, like for what can happen with the TRIPS negotiations. As early as in October, we could meet you all and keep on this conversation over a Turkish coffee in Istanbul. So thank you all so much. Thanks to the speakers who have been so generous about their knowledge, and thank for the audience, the practitioners' audience that spared a little more than 1 hour to think of what IP can become and how we can change the future of IP.